Buckle up, because what starts as a routine traffic stop quickly spirals into a legal rollercoaster involving marijuana, a firearm, and a high school football coach with a suspended license. This is the case of Trevor Flores, a 26-year-old who was pulled over after a dangerous lane change and ended up facing charges for unlawful carry of a weapon. But that's not even the wild part. From the smell of weed triggering a vehicle search, to the gun found in plain sight, to the judge laying down absolute fire about bond conditions and license violations, this case unfolds like a legal drama, with real consequences. And just when you think it's open and shut, a jurisdictional twist throws the whole traffic stop, and the officer's authority, into question. Did the cop even have the legal right to stop Flores in the first place? Is the evidence admissible? Stay tuned, because you're about to see a courtroom debate that walks the tightrope between law, logic, and sheer courtroom heat. Let's get into it.
Mr. Flores, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
Officers initiated a traffic stop after observing the defendant cross several lanes while failing to signal and almost causing a collision. Upon contact, the officers observed an odor of marijuana. The officers asked the defendant to step out of the vehicle and asked whether the defendant had marijuana inside. The defendant admitted he did have marijuana inside, as well as a firearm. During the search of the vehicle, the officers found a handgun in plain view on the driver's side floorboard, not in holster. And the officers also located 13 grams of marijuana under the passenger seat.
Got it. All right, Mr. Flores, I'm going to find that there's probable.
So what exactly does probable cause mean here? When the judge says there's probable cause, he's not declaring Flores guilty. He's simply saying there's enough evidence to move forward with the case. Admitting to having marijuana and a firearm in the car during a traffic stop. That's more than enough for a probable cause ruling. Also worth noting, unlawful carry of a weapon in Texas becomes a much bigger issue if it's paired with illegal substances. The firearm wasn't in a holster and was placed in plain view. Those are serious aggravating factors. Viewers, here's the question: should just the smell of marijuana be enough to warrant a full vehicle search and weapon seizure?
Cause to go forward with your case. Do you have a valid Texas driver license? Do you not?
I have a SR22 in place. My license was suspended.
Okay, you're not allowed to drive. Do you understand?
Yes, sir.
If I find that you drive, I will have a contempt hearing. It's possible you face another 6 months in jail. I'm going to have you sign an affidavit with me today, promising you that you're not going to drive. Do you have liability insurance in your name? Car insurance?
Yes, sir.
Okay. I don't want you driving until you have a Texas driver license. You need to call DPS, figure out what to do to get your license. I'm going to give you the phone number now, but it's time for you to get your license back. And when you show me that you have your license and that you have car insurance, I will happily allow you to drive. But until that.
Let's pause right here, because this is one of those moments where the judge's tone shifts from legal formality to pure warning mode. Flores is clearly confused about his state Route 22 insurance and whether that allows him to drive. But the judge lays it out: if he drives again without a valid license, he's risking jail. This is a bond condition, which means it's a non-negotiable rule Flores must follow to stay out of jail until his next court date. The judge isn't messing around. He even warns Flores about contempt of court and a possible 6-month sentence for violating bond terms. Have you ever seen a judge go this hard on something as simple as driving without a license?
I mean, I can't give you legal advice, okay? But as it stands, until you have a Texas driver license and liability insurance, don't drive. I'm also ordering you as a condition of your bond not to be in possession of any weapons as well. Do you understand? This is a condition of your bond. If I find that you have a weapon, I'm going to revoke your bond. I'm going to put you in jail. You will not get any more PR bonds. Do you understand, sir?
Yes, sir.
How old are you?
26.
What do you do for a living?
High school football coach.
And I see it is not eligible, and it says it's a mandatory suspension due to driving with license invalid, as well as an SR suspension.
If you're wondering what an State Route 22 is, it's not insurance. It's a certificate proving that someone is carrying the minimum liability insurance required by the state, often issued after serious driving violations. But even having an State Route 22 doesn't override a mandatory license suspension. Flores' license is suspended due to multiple violations, and it turns out, he wasn't eligible to drive at all. Combine that with the gun and weed in the car, and it's a legal cocktail that could blow up fast. Viewers, should repeat driving offenders be treated as seriously as gun offenders in court? Let us know in the comments.
Yes, sir.
Okay. Here, Stephen, do you mind giving this to me, please? This is the number to the driver's license division to DPS. You need to call them in the morning to figure out what you need to do to get your license back. Don't call them at 9. Don't call them at 8. Don't call them at 1:02. You're never going to get through. You need to call right when the phone lines open, which is at 7 o'clock in the morning. You'll get through, give them your license number and ask them what you need to do to get your license back.
Okay.
Once you do, I'll tell you, I'll take this off, you know?
Yes, sir.
Did you want to apply for an appointed lawyer?
Yes, sir.
Okay. I need you to fill out an application for me. I'll take a look at it. And then assuming you qualify, I'll give you a lawyer today. I'm going to have you sign this agreement with me today that you're not going to drive. And I want you to understand, Mr. Flores, I take this so serious. Don't drive. If you drove here, you can't drive home.
No, I didn't drive here. My father did.
All right. So I'll have you come up here, swear to us. I'm going to have you go to Jamae, sign a reset, and then we'll have you fill out the application. Okay?
Okay.
All right.
Bringing a shared code book at the moment. We may have to have you look at a couple interesting things.
Okay.
And this is on the Trevor Flores case, Judge, and I think you visited with that gentleman earlier. He's present here in the courtroom at the moment.
Okay.
But I got the case this morning. I've had a chance to do a kind of little bit of digging
Cursory.
into. Yes. And although we are still waiting for the bulk of discovery in the case. He's charged with unlawful carrying of a weapon following a traffic stop. And I've got a map that is kind of intriguing. I think you'll find just with the way it's drawn. But he stopped by an officer with the City of Bel Air Police Department. And may I approach to just show you this delineation? This is, but he's pulled over.
Here's where things get spicy, because Flores' lawyer is about to flip the table with a jurisdiction bombshell. He claims the officer who stopped Flores wasn't even operating within their legal authority. That's right, the lane change may have happened outside the Bel Air Police Department's jurisdiction, which could technically make the entire stop invalid. Why does that matter? Because everything found after an unlawful stop, like weed or a gun, can be suppressed in court. It's like it never existed. Can one wrong turn by a cop undo a whole criminal case? In Texas, we are about to find out.
Over going.
I know the area
on a
well.
northbound. He's pulled over going northbound on 610 as he, what is described as makes an unsafe lane change. So he's northbound on 610, wants to get on 59 to go southbound, is erroneously in the wrong lane going northbound. The officer says that she has observed him makes that unsafe lane change, and that lane change is outside of the City of Bel Air Police Department jurisdiction. Now, we have a particular statute that governs whether officers can have the authority to make a detention of someone when they are outside of their jurisdiction. And that's 14.03 of
Their
their.
PD can still stop someone outside of Bel Air.
We're not for, well, according to the code, it says a peace officer.
That would mean that any officer.
This part is a masterclass in courtroom chess. The judge and the attorneys are parsing Section 14.03 of the Texas Code of Criminal Procedure, which limits what an officer can do outside their jurisdiction. Sure, a peace officer can arrest someone they see committing a felony, but a traffic violation like an unsafe lane change, that's off limits. And here's where it gets messy. If the stop itself was unconstitutional, then the search, the weed, the gun, all of it becomes questionable evidence. So we ask you, should a technicality like jurisdiction outweigh what was actually found in the car?
Arrest as in
So
being
you
arrested.
would be saying that really if he had committed an ag rob, right? Or
Well,
kidnapping, then even if he had kidnapped, like let's say he had a 2-year-old child in the car that he had kidnapped across state lines. Well, then according to this, because he's in a different jurisdiction, then he couldn't arrest him on that kidnapping charge
Well,
too.
if he saw a kidnapping taking place, the officer could arrest him under that code. But what he can't do is when there's a traffic code violation, we don't allow for example, the El Paso Police Department to come to Houston and then sit on the street corner and arrest people for traffic violations. We don't allow them to make those stops. And that's what's at issue here is a peace officer who's outside of his jurisdiction able to enforce the traffic
I
code.
know where you're going and I've seen it before, but I'm not.
And we're looking at G1, Judge.
Mr. Williams, taking your time.
Where exactly did it occur anyways?
Let me see if I can pull up
So I
the
think-
address. We don't have like any discovery in
Sure.
this case. I don't have any dash cam or anything like that.
So what it says in there is 5600, 610 northbound. And what's so curious about this is
Is that still in Bel Air? Is it
no,
outside?
that would be outside of Bel Air too. And going northbound, southbound lanes are covered in the city of Bel Air. The northbound lanes, for some reason, are not.
I don't know. We'd have to look closer. I don't know.
Yeah, I'm
mean,
happy to
it's
look
something
further
that
into this.
You have to
Judge.
look. I mean,
can't make
I
any-
can't make that determination now.
Fair enough.
Number two,
Yes.
he's not arresting him on a traffic offense.
Well, and I think what the code contemplates when it says arrest, and I think there's case law on this, is that it includes the concept of detention.
Now you're watching two worlds collide, statutory law vs. judicial interpretation. The judge is pushing back hard, questioning whether the Texas legislature really intended for a peace officer to be powerless just because a lane line was crossed outside city bounds. And the lawyers come back. It's not my theory, it's the law. Boom. The courtroom becomes a battleground not just for Flores' case, but for how laws are applied in real-world policing. And when the judge starts using wild hypotheticals like, what if there's a kidnapped child in the car? You know he's trying to expose a flaw in the statute's logic. It's not just a court case, it's a legal philosophy war.
As that's been, because I think when that code was written.
And so what I'm saying would apply as well, though. Like if he catches a 2-year-old kid, right, that's been kidnapped, by your theory, he wouldn't be able to arrest him on a kidnapping charge too.
Well, it's not my theory, it's the code.
If he has a dead body in the car, he wouldn't be able to do it.
Well, that's a legislature question. And I mean, but they wrote that.
I can't imagine that the legislature intended that. I think that they intended for a traffic, let's say for speeding, right? Or your tail light is out. Yeah, not to arrest in that respect. But he goes up to the car, smells marijuana, sees a gun in plain view. I can't imagine the legislature intended in that purpose.
And my position, of course, is that, this may be for a motion to suppress later down the line, and I think there's still
But
plenty more to do in the
it's a
case.
freaking awesome argument.
Well, but the idea
I love you.
is
Mr. You're wonderful.
no right to
Great.
detain him.
Right? Really?
I appreciate the judge, and we'll get.
I'm not ready yet,
Yeah.
but build it. If you build it, they will come. And then we'll take a look down the road and yeah,
Thank you, Judge.
for sure.
Oh, don't forget your phone.
So where do we land? Trevor Flores is facing unlawful carry charges after a traffic stop that may or may not have been legal to begin with. He admitted to having marijuana and had a gun in plain sight, facts that typically seal a case shut. But now the defense is raising a powerful argument. If the stop was unlawful, everything that followed could get thrown out. This case is far from over, and it hinges on a single detail: where exactly did that lane change happen?